So welcome to the last panel of the day. We have the title Stewardship, Hedge Fund Activism and Controlling Shareholders, What Can and Cannot Be Learned from the UK. Okay, now, if you ask me about the things that cannot be learned from the UK, I could be impolite and give you a list like, tracing apps and all these kind of things, but that's not what we're here for. We're here to talk about stewardship and corporate governance. And it is a fact that the UK is a master at corporate governance, and they're also very good with words. And they have been an exporting nation of corporate governance practices and ideas from the outset. And we are here to discuss this with distinguished colleagues. So first of all, we will have two presentations, one from Dan Puchniak and another one from Dionysia Katelouzou. So Dan is Canadian, but is being transported to Singapore. And Dionysia is originally from Athens and works in London. My name is Marco Becht, by the way, and I'm German and I work in Brussels. So that's a good start. And then we will have a discussion of their presentations, which is going to be led, first of all, by Mats Isaksson, who is a Swede who's been running corporate governance things at the OECD forever. I think ever since you drafted the first governance guidance with Ira Milstein, in fact, so there's a loop here to the Milstein Center. And then, of course, we are going to have Mariana Pargendler, who is joining us from Brazil. And then, last not least, we have Fred Samama, who works for Amundi and who's one of the world's global experts on anything to do with responsible investment and climate change. So I'll not take much longer. Let me just say two more words about the UK. So, of course, the UK, in some sense, invented the corporate governance code with the Cadbury Code. And this has been a smashing success. In fact, if you'd asked me at the time which would be the first country to copy it, I could have given you all sorts of guesses. Maybe the US. In fact, it was France, which, sort of like threw me. Now, Mats remembers this very well because, of course, when the French copied the UK code, British thinking and British reality hit the reality of the world, which is that except the UK, the US and Japan, most other countries have, of course, something called a controlling shareholder. And the UK code didn't quite fit, but all the same, it was adapted in many different ways. And you now have corporate governance codes everywhere, including the US. Now then, at some stage, and the original codes already included some provisions, not just directed at companies, but directed at investors. There were recommendations of what investors should do. And that's, of course, not completely logical, because if you have a document addressed primarily at companies, why do you have something in there that's addressed at investors as well? It's not the same target audience. So Britain realized this at some stage, and then they came up with two ingenious insights. One was to separate the two documents, which makes complete logical sense. But that's not enough. You also need something else. You need to have a good name. And they invented the word stewardship and stewardship code. So we know that corporate governance codes are pervasive, and we've had challenges implementing them, for example, Mats, with the OECD principles. And we now have stewardship codes. And this brings us straight away to our first two presentations, because they're about stewardship codes the stewardship code originating in Britain, traveling the world. How has it traveled, and what does it look like when it is arrived in other jurisdictions? So with this little introduction, I give over straight away. I think Dionysia, you go first. Is that right?
Yes, that's
the floor's yours.
Thank you, Marco. Let me share my slides first. So, hello everyone, hello Marco, and thanks for putting the global stewardship into perspective. Like previous speakers, I would also like to say a big thank you to Jeff for inviting me. And of course, special thanks to the Milstein Center of the Colombia University, and of course to Elaine for making this happen. And I'm truly grateful to be included in this panel. So today, together with my colleague and very good friend, Dan Puchniak, we are going to shift a bit the discussion, and we are going to be speaking to you about the global development of stewardship regulation, drawing from an extensive comparative analysis of stewardship codes that have been adopted across 19 countries on 6 continents. Of course, when I'm talking about stewardship as a form of regulation, I understand regulation in a much broader way, as including not only state-driven law, but also market-invoking regulation. This research is part of a large project on global shareholder stewardship that brings together 33 academics from 27 different universities around the world. The Global Shareholder Stewardship Project began in late 2018, when Dan and I started discussing stewardship. And the inaugural event was a Global Shareholder Stewardship Conference that took place in London last September. So the conference was the first to examine the plethora of stewardship codes around the world, and concluded that despite the apparent global convergence of stewardship codes, especially in terms of their form, their content, and the number of principles, the codes significantly differ in application and scope. And what is more, the underlying motivational purposes of the adopting countries vary considerably also. So the conference papers turned to book chapters and will be published as part of an edited book on global shareholder stewardship in 2021. And you can find more information about the project and the conference report and some short videos from us on the project's website. So to understand the global trends on stewardship regulation, I think it is important to understand where and how did stewardship started. And I think that Mark already addressed some of that in putting stewardship into perspective. So UK policymakers had long regarded institutional shareholder engagement as vital to corporate governance of public companies, but had deliberately sought to induce institutional shareholders to develop their own self-regulatory responses to public concerns arising from underperformance. So the first preliminary stewardship initiative, even though the word stewardship was not really used back then, can be traced to the statement of the principles on the responsibilities of institutional shareholders, which was developed by the now dissolved Institutional Shareholders Committee back in 1991. And the committee was set up back in the 1970s by 4 institutional investor associations in the UK, the one on pension funds, the unit trust, the investment trust, and the insurers. And the ISC statement set out non-binding best practices for institutional investors and their agents in relation to the responsibilities in respect of UK invested companies. So those principles were an attempt by the institutional investors to self-regulate themselves, thereby pushing back any government intervention in respect of institutional shareholder engagement, especially following the Miners Review in 2001, which recommended a statutory duty on asset managers to intervene in companies by voting or otherwise. This 1991 statement was slightly revised in 2002, then again in 2005 and in 2007. And in the wake of the UK banking crisis, the role of institutional investors was again brought to the fore, especially because of the Walker Review of 2009. So the critique back then was that institutional shareholders have been uncritical of risky business practices in their invested banks and should have monitored board risk management. So on that basis, the Walker Review proposed that those who have significant rights of ownership, like large institutional investors, they should also have a stewardship duty. So as a response, the ISC turned the principles to a code to encourage institutions to be more active and engaged. This code received bottom-up acceptance among institutions in the UK, and as a result of the Walker recommendation, the FRC adopted that formally as a stewardship code in 2010. So in 2010, the stewardship code was adopted formally by the FRC, and that's the first time that the word stewardship appears in the title of such initiatives, which is a choice that perhaps reflects the expectations for institutions, that to engage with their invested companies is a matter of stewardship. The code is addressed to asset managers and asset owners investing in UK public companies, and applies on a comply or explain basis. And it is faithful to the spirit of the previous ISC code and focused on stewardship as a basis of shareholder engagement and monitoring. And that's why it has 7 principles focusing on monitoring, escalating activities, conflicts of interest, development of stewardship policies, and reporting. Following the case review's emphasis on promoting stewardship across the equity and across the investment chain, the FRC revised the Stewardship Code in 2012. So the 2012 version brought a much more expansive form of stewardship, focusing not only on engagement, but also on stewardship as a means to improve the accountability of institutions to their own clients and to their own investors, and achieving efficient investment management. But essentially, the 2012 version has the same 7 principles, and that's why the 2 codes together have been described as the first version or the first generation of stewardship codes. You shouldn't forget, though, that those codes are voluntary. So this means that institutions that do not in reality regard engagement as key to their investment management approach may nonetheless feel pressure to conform and thus sign up to the code. So these institutions may take a cosmetic approach to the code in order not to incur too much cost, but they use their signatory status to brand themselves to investors. So the FRC identified this issue of patchy compliance with the Stewardship Code, and that's why I introduced a tiering system in 2016 to distinguish between those signatories who are genuinely active from those that free ride on the stewardship brand. So despite the improvement in reporting following the introduction of the tiering exercise in 2016, the Kingman review in 2018 concluded that the Stewardship Code, whilst a major and well-intentioned intervention, is not effective in practice. And according to the Kingman review, the Stewardship Code focused too much on the procedural aspects on engagement, but not on real outcomes. So the FRC directly responded to those criticisms and revised the UK code with a focus on outcomes. And the 2020 version of the UK code introduced a significant overhaul to how we understand stewardship. The code has 12 principles. It's not only about engagement anymore, but it's also about investment management and about what Jeff describes as systematic stewardship. And there is an emphasis on ESG factors. So what I tried to show you so far is that UK policymakers have expressed their faith in the capacity of institutional investors to act as stewards of listed companies, and have over the last 20 years promoted policies aimed at encouraging them to become more engaged in the corporate governance roles. But the question here is, can we really expect from institutional investors to act as stewards? And do stewardship perceptions of the investors themselves cohere with policy narratives? So in the paper I prepared for this conference, I address these questions by providing new and original evidence from the point of view of activist hedge funds that have signed up to the UK code, to the first generation UK code. The choice to focus on activist hedge funds is not by chance. First of all, as we saw from the earlier panels, activist hedge funds are the best candidates for stewardship because they focus on firm-specific investment. But at the same time, activist hedge funds, actually there is a negative perception of activist hedge funds, especially in the US debate, but also elsewhere. And activist hedge funds have been criticized as unfaithful corporate governance participants that, look for short-term profit. So the question this paper tries to address is the way activist hedge funds and similarly active asset managers in the UK understand stewardship. I'm not going to delve into the methodological details, but the study constructed a textual data set comprised of all the public statements of those 19 activist signatories. The final corpus consists of 28,438 words, which were analyzed using the method of automated content analysis and structural topic modeling. So what are the key findings of the analysis? So the empirical findings elaborated that the notion of responsibility is much more impeded in the rhetoric of tier 1 signatories compared to tier 2 signatories. So in other words, tier 1 signatories seem to regard themselves as able to carry out a governance role for corporations in the wider public interest. Whereas on the other hand, tier 2 signatories seem to understand stewardship as a corporate governance mechanism and associated with voting and best corporate governance practices, such as independent non-executive directors. Now, in terms of the extent to which the rhetoric of stewardship coheres with the UK Stewardship Code principles themselves, the empirical findings suggest that in terms of disclosure and transparency, the statements do not really focus too much on that. So this seems to confirm the earlier criticism by the Kickman review. But on the other hand, what I found, which is maybe surprising, is that tier 1 signatories place a heavier emphasis on ESG compared to the code itself. So in other words, in terms of responsible ownership, it appears that the signatories, at least in terms of the statements, went a step further from the UK code itself. So it is clear from the findings that there is a gap between tier 2 and tier 1 statements. So it seems that tier 2 signatories understand stewardship in a much more instrumental way, as relating mainly to engagement and monitoring, whereas on the other hand, tier 1 signatories appear to have a more social and environmental friendly orientation in the way they perceive stewardship. So their understanding can be described as more enlightened in the sense that they've used stewardship as a means to address major societal goals, including climate change. So the difference in the way stewardship is understood by activist signatories has important implications for the signatories themselves, because it becomes clear that if you're a tier 2 signatory and you want to move to tier 1, and potentially you want to attract more clients, this is contingent on a more holistic, enlightened understanding of stewardship. So what can be learned from the UK and what can be learned from this study? First of all, it is clear that soft law stewardship codes are flexible and they're adaptable to changing circumstances. And if you look at the UK history of stewardship, you can see that between 1991 and 2020, there are 8 different stewardship initiatives. And that's not just a UK trend. There are also other countries like Italy, the Netherlands, and Japan, where there have been, where the stewardship codes changed to reflect the changing circumstances. That's lesson number 1. Lesson number 2 is that it seems that informal enforcement by market actors is probably the preferred option, especially when we're talking about market invoking regulation, but at the same time, some market steering is needed. And we can see from the differences in the signatory statements between tier 1 and tier 2 that being in tier 1 does make a difference. The third message is that the 2020 code and the emphasis on ESG is a step to the right direction and is in alignment with the way tier 1 signatories were already perceiving stewardship. And finally, the empirical findings confirm that hedge fund activism and stewardship are not incompatible, especially for tier 1 signatories. But of course, one needs to bear in mind that those statements are also aspirational. So more research is needed on the real outcomes. So these findings are even more important if one takes into account that stewardship codes now exist across 19 countries around the world. And on the slides, you can see a figure that we prepared as part of another paper with Matthias Ziems, where we studied the relationship between the different codes. And we found that the UK code is at the center of the stewardship network. And even though diffusion processes are too varied and too complex to be reduced to a direct one-way transfer, it seems that there is a strong evidence of formal diffusion among common law countries in Asia. So I suppose the question that Dan is going to address is whether behind this formal diffusion, there are renegotiations or perhaps constellations of stewardship at the local level. Thank you.
So I just want to start by really thanking Jeff for pulling this all together, the Milstein Center for organizing this, ECGI, and Elaine. They always do such a terrific job pulling these things together. And also a special thanks to the OECD. Really, this paper that I'm presenting with my co-author, also from the National University of Singapore, Ernest Lim, couldn't have been done without this terrific data from the OECD. And not only have they produced this wonderful paper, which we must cite 20 or 30 times in our paper, but they also shared with us unpublished data which I'm very, very grateful for that. I guess Dionysia has set the stage very well for me, and there's not much to say about this. In 2010, the UK created the first code of corporate governance in the world. And then very quickly, codes started showing up everywhere in the world. And as Dionysia said, there are now 19 jurisdictions with codes on 6 continents all around the world. And the basic question that we ask at the start in the paper is we say, okay, these codes have gone everywhere. Are they the same as the UK code? And so what we did is very basic, but was a bit time consuming. We went through all of the codes, we read them, we tried to find equivalent principles. And there's a rather long section in the paper that tries to prove this in various ways. But to cut a long story short, you can see from the slide that it is very, very clear that the codes that have ended up around the world are very much a copy of the UK code. So the UK code has been transplanted in large part, with some minor exceptions, to these 19 jurisdictions around the world. And being someone who's sitting now in Singapore, this created a puzzle. And the reason why it creates a puzzle is because the code, and what we call in our paper, creating a global legal misfit. And what is the misfit is, at the core of the UK code, there is an assumption. And the assumption is that if institutional investors act collectively, that institutional investors can control most companies. So the debate in the UK, and historically this has been the case as well, and in the academic literature, and in the code itself, there is an underwritten assumption that institutional investors have control collectively. But the question is, can we motivate them? Can we incentivize them to be active and to take control? But that assumption works also in the United States, but it doesn't work anywhere else in the world. And if you look at, there's 2 reasons why it doesn't work. The first reason has to do simply with the average percentage that is owned by institutional investors in non-UK countries. Now, if you look at the average statistics for the average listed company in the United States, 80% is owned by institutional investors. In the United Kingdom, 68%. So clearly in these jurisdictions, and this is why you get the famous phrase absentee landlords in the UK, was because they said, well, we have institutional investors that own all of the shares, but they're not doing anything to involve themselves in the corporate governance of the companies. And I don't use this wording in the paper, but I'm thinking of maybe putting it in there now, which is that when you get outside of the US and the UK, you don't have absentee landlords, you have absentee tenants. Because even if these people come together, they can't control the company. And if you look at the most extreme example is within Asia. In Asia, institutional investors on average in the Asian jurisdictions have 11% ownership. And you have several jurisdictions where they have less than, they have single digit ownership. So if they come together, they don't even have enough to form a blocking, a veto minority. The other side of the coin is that, different from the US and the UK, in most other jurisdictions in the world, listed companies have a large block shareholder. And I was actually surprised when we started calculating based on the OECD data, the dramatic difference, which is that, and you can see on the chart here, that the average company outside, or the average jurisdiction outside of the US and the UK, 61% of companies have either one shareholder or their top 3 shareholders that own 50% of the shares. Half of the countries outside of the US and the UK 70% of their countries have such an owner. So these are rationally active block shareholders. So there's no problem with ownerless companies, or I shouldn't say no problem. Of course, there's some variation, but by and large, companies have rationally, or countries and the listed companies in those countries have actively or rationally active owners. And so the question then becomes, why do you need a stewardship code when you already have stewards? That got us to the next part of our paper, which draws hugely on this project that Dionysia first launched, and I've been riding on her coattails ever since. And this has produced in-depth reports on every jurisdiction with a stewardship code. And when you go through those reports, it's fascinating because you ask yourself, well, if there's such a misfit, why are these countries adopting a UK code designed for a system where institutional investors can take control? Why are they doing this? Why don't they draft a code for controlling shareholders? Or why are they bothering to implement these or adopt these codes at all? And I could go through story after story, but I don't have time. I'll just list off a few. The end result, though, is that these UK-style stewardship codes have been adopted in non-UK jurisdictions for reasons which would have never been anticipated by the people who drafted the UK code. And because they were adopted for those reasons, they've also come to serve these functions that you would never even think of. To give an example, in Singapore, and the details of all of this are in the paper and in the supporting papers, Singapore has adopted a stewardship code which largely serves to reinforce its state-controlled and family-controlled system of corporate governance. If you look at Korea, Professor Chan and Professor Kang wrote this terrific case study on Korea, and they say that critics in Korea have, they claim that the Korean government has pushed stewardship so that they can use the national pension shares and bring along other institutional investors to force them to sign up for stewardship to intervene politically in the corporate governance of companies. So this is a political motive that these critics call pension fund socialism. In Japan, Gengoto at Tokyo University has shown that Abenomics was the driver behind the Japanese stewardship code, and it was used to bring more shareholder focus, not stakeholders focus, to bring more short-term thinking, to cause companies to take more risk, not less risk. Again, turning the UK model on its head. Many other examples, a very interesting one, just because of what's in the news these days, if you watch the news on Asia and the protests in Thailand, the military junta in Thailand passed a stewardship code. It was very much modeled on the UK code. And you have to ask yourself that question as to why. What was the motive of doing this? It doesn't fit their shareholder structure. And you can see a political motive. Outside of Asia, you have a different story, which is that most of the codes are different from the UK in that they're not passed by governments, but they're put forward by a coalition of institutional investors. In those cases, the motive is normally quite straightforward, which is that institutional investors generally want to stave off the government passing an act, and they put out a code for that purpose to serve their interests. We then go on in the paper, and I'll move quickly because I know I'm short on time. And what we do is we say, okay, are there any jurisdictions in the world that have actually tried to tailor a stewardship code not to the UK model, but to the controlling shareholder problem and the shareholder makeup in most jurisdictions around the world? And indeed, there's only one code that has ever done this, and it's in Singapore. In Singapore, there's two codes, one for institutional investors and another one for family businesses. And we go through the code and we talk about how this is quite an interesting development. Another thing that you notice in recent codes, and this shows up, of course, hugely in the 2020 UK code, is a focus on ESG. And so we asked the question, well, can stewardship in a controlling shareholder jurisdiction, if it is drafted in a way to fit the system, can it solve the ESG problem? What we end up concluding, Ernest Lim and me, is that stewardship will probably be one tool, a weak tool in controlling shareholder jurisdictions. We're not overly enthusiastic about it, but we suggest that mixing it with hard law may not hurt. It may be somewhat useful. It will be one tool in the toolbox. We definitely suggest that in the future, if you are going to understand stewardship, you're going to have to understand it in controlling shareholder jurisdictions. Why do we say that? Because that is the state of the world outside of the US and the UK. And just to end, maybe on not the most positive note, our feeling at the end of the day is that what the future will hold for stewardship is that in more jurisdictions, institutional investors will come together, especially in the time of COVID and post-COVID. They will want to express or to be seen, to be taking care of ESG, taking care of society as a whole. Governments also will feel this pressure. And stewardship is a cheap, malleable, easy to copy instrument that is soft law. And we're probably going to see more of these codes. What we say will be needed to solve the heavy lifting or to do the heavy lifting in controlling shareholder jurisdictions is a focus on hard law, not on stewardship. And we are skeptical whether these hard law fixes will be put in place because, after all, the so-called stewards in controlling shareholder jurisdictions are the state itself, wealthy families, wealthy individuals, and those people tend to be very good at preventing regulation that ends up biting them. So a lot of bright lights, but little bite at the end of the day. Thank you very much.
Thank you, Dan. Mats, we are running already a bit late, so straight over to you.
Very good. And to Paris, and thank you very much again for having me, and to the Milstein Center and ECGI, longtime friends of mine, and very valuable sources of research and debate on these issues. I should say that I would speak in my personal capacity. So all I say is not necessarily shared by the OECD or its member states. As you can imagine, I am very pleased to see a data-driven, empirical-based paper, and this is very much in the spirit of the OECD. And I think you've also made very good use of the work by my colleagues Alejandra, Adriana, and Yun. And this search for knowledge is the starting point, I think, for any good discussion. And the knowledge that we need more than anything else for today's discussion about stewardship is knowledge about the ownership structure and, most importantly, the incentives that comes with the ownership structures and the business models of the different intermediary owners. And by this, I mean not some sort of abstract incentive of an organization, because in a sense, business organizations do not have incentives. People have incentives, individuals have incentives. So my proposition would be that the behavior of organizations is sort of the lump sum, in the sense of not of declarations, but of the incentives of the people that populate these organizations. So right there, going back to Rebecca Henderson's emphasis on a collective action problem, we actually have a collective action problem even within our financial institutions. I don't think I've ever seen I mean, it has to do with remuneration structures, bonus systems, incentives, etc. And I don't think I've ever seen anybody voting proxies being able to retire comfortably at the age of 37. But I have met and I have friends in the fund management industry who are asset managers who have, and some of them didn't even know at the time that they retired that they had a corporate governance department in their firm. So I think that says a lot about what's actually is going on in the industry if we take a bit of a look under the hood and look at the different incentives and remuneration structures that actually drive the real behavior. And once we understand this, I think we will also realize the difficulties of translating the wish for an indexer, as Lucian said in the morning, their wish to be perceived as a good steward. The difficulties of translating this actually into practical, good, and informed ownership and stewardship that actually costs a lot of money. So I think the practical effect, and this is what a stewardship code is up to in reality, if you want. I mean, you may write these things on the paper and then you're confronted with these incentive structures and business models of the institutional investors, which themselves comes in different shapes and forms. I mean, it's an asset manager, a pension fund, a public pension fund, a private pension fund, an insurance company, what have you. I mean, they all have different business models and different incentives when it comes to engaging in stewardship and investing all the money that is required to do it well. And this is what the codes, in a sense, are up against, trying to herd in one direction. And I think that for practical purposes, this is a bit like Dan's picture as well. It's like fitting a square into a round hole. It will just not work out as intended. So what is the problem then? Is there a problem? Couldn't one just be agnostic about these stewardship codes that are proliferating around the world? Perhaps one could and say, let them put them out. You know, it engages a lot of people to draft them and discuss them, etc. They even generate some good academic work. But I would say that there is actually a potential downside, because if the political pressure or the social pressure, in a sense, to comply with these stewardship codes becomes too high, we may turn into a simple compliance, boilerplate, box ticking exercise. And this can indeed have adverse effects on the need for developing idiosyncratic new arrangements in individual companies. I would say, particularly with respect to companies that operate in other legal contexts than the asset manager is usually familiar with. And you know as well as I do that there is more than one testimony from national asset managers being horrified by large global asset managers who are voting against their own interest just because they don't understand the local context in which the company operates. When we developed the OECD principles of corporate governance in 2000, between 2013-14, and they came out in 15, there was also this discussion about the role of institutional investors, and we actually inserted a whole new chapter about institutional investors, and the discussion about stewardship came up, and whether there should be some stewardship code, recommendations, etc., from the G20 OECD. But what our member states actually did was they stopped short of this quite explicitly, and they even, and I think I'm quoting when I'm saying that the current version of the principle says that whenever shareholder engagement is not a natural part of a shareholder's business model and its investment strategy, mandatory requirements, for example, to vote, may indeed be ineffective and lead to a box-ticking approach. So I would say that there is not only a lot of perhaps false expectations and misdesign of these stewardship codes if you don't look at the incentive structures, but there also could be a bit of adverse effects when it comes to their implementation. Because what we are trying to do in a sense with the stewardship code is to transform an animal, or rather a big variety of animals that we call intermediary investors. And as I said, they come in different shapes and forms with different incentive structures within themselves. I mean, we're trying to transform them into something that would look like the original Burleigh means direct investor, if you want, and have the same incentives to engage, etc., etc. Maybe the door has closed when it comes to that ambition. Maybe what we should do is to look forward to new solutions as corporate organizations change, as capital markets change, as the functioning of our equity markets are changing. And there could be a number of developments that and rather than sort of petrifying the system in this mold and dream back of a time when shareholders were supposed to be directly engaged and put a lot of attention and scrutiny into individual companies, maybe we should at the same time make sure that we have the door open for new versions. And I think this is for new idiosyncratic models for corporate governance. And I think this is already happening. I mean, if you see a lot of the new technology companies that enter the stock market at a fairly late stage, well-funded, etc., they do have different governance structures, if you want, than the traditional corporate governance model. And investors very much seem to accept this. So I think I'll stop there, Marco, and give the word back to you.
Thank you, Mats. So, Mariana, the view from Brazil, the country with the most controlling shareholder-friendly corporate law regime in the world. The floor is yours.
Working hypothesis, Marco. So first, thank you to Jeff for this wonderful invitation. Congratulations to the Milstein Center and ECGI for putting together this great event. I must say that in the early stages of my career, I had the great privilege and honor of working together with Ira Milstein, both as a junior lawyer and researcher at the Milstein Center. So it's very special to have the opportunity to speak at a Milstein Center event. It's also a great privilege to comment on Dan's and Dionysia's great paper. So my comments will focus on the question of where do corporate governance developments come from? We all know they can come from domestic needs and dynamics. They can also come from foreign jurisdictions, and this relates to the theme of legal transplants in comparative corporate governance, which is actually part of the title of Dan's paper. But I'd like to highlight also the international dimension, and that relates perhaps to Mats from the OECD and also from other international organizations and standard setters, and their role, which is often neglected in pushing for corporate governance developments. So beyond Dionysia's great work in distilling the text, I want to talk a little bit more about the context and specifically about what I call the rise of international corporate law, or what perhaps Jeff Gordon would call the global governance by asset managers. So let me give one example from Dionysia's paper. She notes in the paper, although not in the presentation, that from the 15 out of the 19 hedge funds that signed up to the Stewardship Code are also signatories to the UN principles for responsible investment from the United Nations originally. So one question is, how does the Stewardship Code's commitments relate with this other, perhaps even prior commitments to the PRI? Some would say that actually the PRI were the first initiative on shareholder stewardship, even prior to the Stewardship Code. Beyond that, and that relates also to Dan's paper. So Dan tries to make sense of a global transplant of a legal misfit. Dan is a great comparative corporate governance scholar in the tradition of being a splitter. Jack Coffey from Colombia says that some people in corporate governance are lumpers, so they see common patterns across different jurisdictions, and some people find distinctions across different jurisdictions. And Dan is a great splitter, and he's doing a beautiful work in this paper in showing the very dramatic importance of ownership structures in understanding the power of institutional investors and therefore the potential effects of stewardship codes. And he wonders, why did those countries adopt stewardship codes if they were tailored to the UK's reality of dispersed ownerships, as we no longer live in colonial times when a country would just impose its laws on another jurisdiction, and the decisions of governments around the world to adopt UK-style codes even appear to be irrational. And I'd like to give greater context to this idea and perhaps offer some mild pushback. One idea is that actually international corporate law might have played at least some role in the diffusion of legal transplants, and I actually think both Dan and Dionysia to pushing me to investigate the impact of international institutions in the rise of stewardship codes. And I noticed that for various countries, the World Bank's reports on the observers of codes and standards actually explicitly recommend countries to adopt stewardship codes. That was the case with respect to the assessment for Brazil, and lo and behold, a few years later, Brazil adopted a stewardship code. So there might be growing international pressure from these international organizations and standard setters to adopt those codes. The G20 OECD principles do mention stewardship codes, even though they don't necessarily mandate it, but the expression is certainly there as one policy option for countries to consider. And then there's the question, why is it that those international organizations care about stewardship codes? And here I want to offer two interpretations. One is that international organizations have played a role in resisting what I call the grip of nationalism on corporate law, which is the idea that countries might want from time to time to expropriate or perhaps not be exceedingly friendly to foreign investors and instead try to favor domestic parties. So certainly stewardship codes place a pattern of legitimacy on the role and ambitions of institutional investors, which might be helpful in an international corporate governance perspective. And the second idea is the growing push, which actually originated in the international sphere. ESG come from United Nations initiatives to use corporate law and corporations and global investors to solve many of the world's most pressing problems, including addressing externalities. And that is important because the externalities are real, and they are real economically, and perhaps that's a key part of Jeff Gordon's paper. And also they are real in creating political backlash against corporations and globalization, and perhaps even capitalism, so that it is important for investors to buy in greater legitimacy. So I'm offering those perhaps complementary interpretations to the rise of stewardship codes. And so in Dan's honor, I also want to offer some further splitting. Okay, so Dan said dispersed ownership is different from concentrated ownership. I get it, and that's a fundamental distinction, but it's also the case that not all countries with controlling shareholders are alike, and there might be actually particular corporate law rules for which stronger institutional investors supported by stewardship codes might make a difference. And I'm thinking here, for instance, about countries such as Italy or Brazil, by which the law recognizes board representation of minority shareholders as a general rule. Also, for those countries that at least in some contexts require majority of the minority approval requirement for related party transactions. In those contexts, it would be very helpful to have active and engaged and informed institutional investors, even though you might have a controlling shareholder. And just finally, it is the case, as Dan suggested, that certainly around the world, outside of the US and the UK, you have a majority of controlled firms, but even in the United States, today we are in a context in which we see the very largest firms having, and I'm thinking here about many of the technology firms, in fact, having controlling shareholders as well, and creating, I think, very important ESG issues, as well as issues of broader legitimacy that might interact in interesting ways with the promise of stewardship codes and institutional investors to solve the world's problems. Thank you.
Okay, so we turn to Fred in a second. Fred has slides to share. So let me just maybe add one comment to what Mariana said. I mean, if you go back to the original paper by Black and Coffee about the UK, Hey Britannia, they have a very compelling example in there that although you at the time still had controlling shareholders in the UK, because of the rights issues rules, actually a minority could go on a capital strike. So the fact that companies needed to raise capital and minorities being able to block that desire of the controlling shareholder actually gave them influence. So the voting channel is not the only way in which a coalition of shareholders can gain influence. But turning to Fred, so when I first read the papers of Dionysia and Dan, one of the facts that you document is that the Stewardship Code, in fact, has been exported mostly to former colonies of the UK. So that reminded me a bit of Marmite. It is something that you like or you don't. And actually, as a matter of fact, those who like it, outside the UK are those in the former colonies. So I think what Fred, has for us is a different view. He, of course, works at Amundi at the frontier of reality. So first of all, I think Fred will argue that actually reality has overtaken us from the left, or if you drive in the UK, from the right. And secondly, that of course, Bon Maman is a much better export product than Marmite. We just haven't realized. So Fred, here you go.
Yes, due to the Brexit, I could not comment on the UK stewardship. You can understand that. So thank you to you, Marco, and Jeff for the invitation. Today, I will focus on 3 topics, actually. Climate change, tipping point, and new responsibilities for investors. Climate change is a green swan. It means that it's very likely you have multiple forces behind climate change that are nonlinear and interacting with each other, meaning that it's extremely complicated to price the risks, like Theresa said before, and it's putting human life at risk. So it means that here we are facing, in terms of risk management, with a massive systematic risk. That's the bad news. The good news is that since the COP21, everything has changed. We have observed that multiple forces are getting aligned and generating a tipping point. And part of this tipping point is the fact that we have a massive wave among the institutional investors. And beyond that, we see more and more market players playing the usual objectives of stewardship codes: control, wealth creation over the long run, and influence. So we have a massive risk, but the world is waking up. Now, however, in terms of climate change, stewardship certainly goes beyond the usual objectives, and we see more and more players who are aiming at improving the market resiliency, and it will be my third part. So before that, in order to deserve the kind introduction, a few words about what brings me here. Actually, 10 years ago at Columbia University, in partnership with Professor Bolton, I launched an academic center dedicated to sovereign wealth funds and how they could or should internalize some externalities like climate change. Later, I launched the first coalition of investors committed to decarbonize their portfolios with a $800 billion commitment. I initiated some financial innovations. I advised some policymakers like the US Senate. I testified before it last March, and I published a couple of papers. So now when we talk about climate change, we are facing an unprecedented challenge. We, the planet, we are producing about 40 gigatons CO2, and we are on the way to double it. We have more and more people on Earth, good news, escaping from poverty, better news, and so on. The problem is that if we follow that path, half of the humanity is at risk, as we will see. So we must shift from doubling the emissions to cutting to almost zero by 2050. We have never faced that. It means that all countries, all sectors, all corporates will be impacted. Is that to be in a very nice and coordinated manner? Maybe, but more and more people have very serious doubt on that. So the magnitude of the problem is unprecedented. And if we fail, it means that at the end of the century, half of the planet will have to move because they will be at risk. Here you have the situation of the deadly threshold per year in terms of number of days. It means that you will not be able to live in Brazil, in South America, not in Central America, part of the US, no more in Africa, no more in India, Indonesia, Australia. So here we talk about human lives being massively at risk. In terms of asset prices, it's not so easy as well, because you have at least 3 blocks of forces impacting asset prices. I won't be long on that, but you have society like millennials that are changing their consumer preferences. You have regulation, they are booming everywhere. Last year, the price of carbon tax has been multiplied by 5 in Europe. And nature, we had over the past 40 years, the number of extreme weather events have been multiplied by 4. By 2050, about 50% of the world population could be at risk in terms of water scarcity. And the problems here is that all these forces are interacting with each other, and most of them are non-linear. So it means that you have a lot of uncertainty and risks on the asset prices. So that leads to a green swan, a term that we coined with the BIS, the Banque de France, and Patrick, by publishing a book earlier this year, saying that certain carries a variety of nonlinear and interacting risks and could put human life at risk. That risk cannot be hedged. That risk goes beyond a corporate investor's way of being solved. As Patrick said as well, we are all part of the answer. It's not about a miracle solution. And it's so big that now 65 central banks, including the Bundesbank, central bank, the Bank of England, Banque de France, Singapore, MAS, and so on, they're all putting climate change on the agenda because they recognize that it threatens financial stability. So all investors are now facing that reality. That was the bad news. The good news is that everything has changed over the past 3 to 5 years. And that's a very short period of time. We have to think about that. Climate change has been on the table for decades and nothing was happening. And suddenly, around the COP21, everything changed. 3 to 5 years ago, we still had some deniers. They have disappeared, but at the White House. It was one of the many risks. Now it's the biggest risk, as mentioned by Davos. You had very limited regulations. Now they're booming everywhere. You had no global agreement and no hope of having one. We got the COP21 here in Paris. China was blocking. Now China is leading. You had a very limited interest within populations. Now it's a top priority for millennials. It was for economists only. Now we can observe in our day-to-day lives. The cost of renewable energy was very high. Now we have very competitive pricings. You had very few European investors. Now world investors are jumping in. And it was a progressist agenda. Now it's in the agenda of central banks. What this slide says that none of these forces is enough to get an impact. But when suddenly they're all getting aligned, then you have a tipping point. And it's exactly what we are observing now. It's a fantastic good news. In terms of investors, what does it mean? It means that suddenly we have a responsible investing tsunami. We have now $30 trillion of responsible investment. And Deutsche Bank estimates that it will grow by 50 to 45 trillion plus 15 trillion by the end of next year, and to represent even $125 trillion by the end of 2030. It's still confusing in terms of terminology and so on, but it says something. Now, in terms of influence, one of the key objectives of stewardship codes, and I could have spoken about votes, I could have spoken about PRI and so on, but I focus on influence. And I would like to elaborate on something that was not so much discussed today, because we discussed a lot about the hurdles that investors could face by cooperating and influencing. But actually, CalPERS at the One Planet Summit here in Paris in December 2017 launched the Climate Action 100. And now it gathers 500 investors representing $47 trillion. That's an enormous amount of money, $47 trillion. And they are engaging with the 160 most polluting companies. And when I say they are engaging, they are doing something very serious. Here I copied the joint press release that Total and Climate Action released. They say, we discussed together, and here is a new policy of Total. So they were concretely able to influence one of the largest oil companies in the world about their climate policy. Now, so we see that the investors are getting mobilized. They are trying to influence corporates. Much more can be done, but there's a momentum. But to conclude on this presentation, I would like to highlight something that Rebecca highlighted briefly with Hiro Mizuno, who has exactly the perspective I will describe here. He said, being a universal owner, I think, says Hiro, that part of my responsibility is to improve markets' resiliency. So it's not only to get returns that will disappear when there will be a crisis, is to make the markets more sustainable for the benefit of my beneficiaries. And I would like to highlight two case studies where investors pushed for innovation. Case study one, a couple of years ago, AP4 and then FR challenged us, and they said, okay, we got convinced on low carb, on climate change. Can you develop a low-cost, plug-and-play, scalable solution to reduce climate change-related risks? And we developed the first low-carbon indexes with their support. They allocated some resources, financially and intellectual resources. And it's now a 50 billion market. And by the way, it tackles many of the issues that were discussed today in terms of index and so on, or passive management and so on. Here, you reduce the weight of polluting companies within indexes, and the very good news is that actually it has delivered more than 30 basis points of outperformances since over the past 10 years. And you have a paper and a case study at INSEAD. Another case study about how to finance some green infrastructures in emerging markets. Here, IFC played the role of allocating some resources, developing a prototype that became available for the others, and suddenly we could deploy $2 billion and allowing a better allocation of capital around the planet. And it's a business model being replicated by AIB and AIB. So what I'm saying with these 5 investors, they said part of our duty is not only to make returns, but to improve market resiliency for the benefit of all. And I think it's a very interesting trend here. And it's part of the message that Patrick carried before, meaning that we are all part of the solution. We cannot count on a miracle solution. So to conclude, the world has massively changed over the past 5 years. The bad news that climate change is a systemic risk, even putting human life at risk. The good news is that you have a global mobilization, including a massive wave among the investors, that market players are achieving the usual objectives of stewardship codes, control, wealth creation, and influence. Stewardship codes are important. They're helping us shift from first movers towards adoption by all. But now, with this very specific risk, that is climate change, that is putting human life at risk, that is the biggest challenge ever faced, we think that stewardship goes beyond the search for alignment between shareholders and corporates, and it includes a will to have markets being more resilient. It's a call for financial innovation, and that's maybe a new utility function for public money.
Okay, so we're almost out of time, but I'll ask you one question based on what Fred said. So I think Fred's argued that, remember, France is called La Grande Nation, okay? So this is the view of we cooperate, this is the big stuff. We have this global investor coalition, people are really behind this. And it resonates a bit about, with what Rebecca Henderson said. So Dionysia, Dan, Mats, are you convinced, was this a convincing argument that this new wave, this new commitment, COP21 and everything else that Fred has said, is this basically putting stewardship codes in perspective? And yeah, they're a tool, but this new development is just sweeping it away, and we can be actually a lot more optimistic than you said. So Dionysia, Dan, and then maybe Mats from the OECD perspective. I mean, does anything that Fred said resonate with you?
I think it was John Maynard Keynes who said that optimism is the highest form of intelligence. So I like to be an optimist. And I also believe that, all decks on hands, because everybody can do something in this very urgent, matter. I think we do have a collective action problem. I believe that both with Leo and with Rebecca, that there needs to be regulation in place in order to get the relative prices of different things in shape, so we can have a carbon tax and actually have polluters pay. I think these are important OECD perspectives. Second, I believe that there is one thing that is important for this to work, because for Amundi and for others to actually achieve what they want to achieve in terms of change and in terms of impact, there needs to be indices and there needs to be ratings that actually reflect what the companies are doing. And we just recently, last month, put out what we call an OECD Business and Finance Outlook that was dedicated to sustainable finance. And one of the things that we highlighted in our findings was that there is quite a mismatch between what these indices promise and what is actually delivered, particularly in the environment area. Second, the ratings that we see out there, and this is all well intended, and we are still early days, are also sometimes even contradictory when it comes to the kind of scores that they provide. And of course, very shortly, Marco, one of the problems is that we bundle all these ESG together. I mean, governance is probably 80% of what corporate governance is all about, right? And how do we weigh them between each other and call them all ESG? I mean, I'm personally a bigger fan of not using the ESG concept, but actually splitting them up. I mean, is shareholder, you know, the structure of a shareholder meeting, how do you weigh that against carbon emissions, for example? It doesn't come natural to me. So I think that if we talk environment, we should talk environment. If we talk corporate governance and differential voting rights or whatever, we should talk about that. But bundling them in one index doesn't make much sense to me, to be honest. What is needed to bring some clarity to this and help the institutional investors, helps the index providers, and help the ratings agency is to have some sort of trajectory towards comparable, consistent, and verifiable disclosure variables on this. And I know that IFRS just recently indicated the first step towards working towards this. And I think before we have that, we should all do our very best, but we should also get to a place where we can give those that want to achieve some good results the tools to actually do so.
Okay, I was going to ask Mariana about Petrobras, but I'm out of time. So let me just thank the panel. And before I hand over to you, Jeff, for your concluding remarks, let me just say that I think we finished here on a note of optimism. I think we heard last night that at least one of the US presidential candidates is committed to an energy transition in the US. I think we heard from throughout the day today that at least the people who participated today are very much in favor of international cooperation at all levels to solve the questions that we have in front of us. And I certainly took all that optimism away from today's meeting. And I think, Jeff, you said it at the beginning, and when you first contacted us about wanting to put together this event, this was your intent. And I think it's come through very loud and very clear. And I'm very happy that we finished on this bullish note of optimism from Fred that I think echoes also with what was said before. Now, I of course thank you, Jeff, but Elaine has also sent me a little note. But of course I have to thank her, but you can do that again, Jeff. So first of all, I want to thank you for putting this on at short notice. And then of course to thank the team at the Milstein Center, so Erika Klein, Brea Hendricks and Chris Mack for putting it all together. And of course for your initiative and kindness and for being such a great colleague, Jeff, and for leading all this initiative and for involving ECGI. And it's always a pleasure to work with you and the Milstein Center. So thank you. And thank you again to the panel. And thank you for Dionysia and Dan for a great paper. Thank you.
Marco actually, well, first, it's always a pleasure to work with the ECGI because Marco and Elaine are so able at what they do, and Marco over time has become a master overseer of all of these activities, and he himself has played a very important role in maintaining the global governance debate, which I think is very important because these issues have a global dimension. Many of them, obviously, the climate change issue is, of course, global, but many others we can't solve really unless we think about the world as a whole. So, but I don't want to I've said what I have to say, really, and Marco really gave thanks to the relevant folks, both at the ECGI and the Milstein Center, who did such great work in bringing this together. I'm mindful of the fact that at 3:40 in New York City, it now is almost 10 in Paris, and you know, in Asia.
You know, Jeff?
I'm not sure what it is. So, so this has really been a testament to the desire for folks at this time of interference with the normal ways that we get together to hold fast to the ideas of discussion and thinking with one another. And it is good to end on an optimistic note, both with the hopes that we will soon have a vaccine and therapeutics that will permit us to re-engage in a personal way when we can all be in the same physical space. So anyway, I was about to say, so I hope it's not only the optimism that comes with the thought of a vaccine and maybe the therapeutics that will shackle us from this particular mode, but also I'm optimistic about a dawn of new politics in the United States. And with that, I hope chance to re-engage the world in a different way. The challenges are very important. So anyway, I hope the day has been successful at rethinking stewardship. And for those who are still online, and we're in 3 digits. The plan is to have videos from the day. We're going to try to edit them, I think. There will be discussions of each session. I hope to be able to get the slides of the speakers. And so the idea is that folks who want to reflect on these further will be able to do so, but also for the academics in the audience, there is a lot of material here, which I think would be great to run a class discussion, maybe a workshop. And so that's part of the reason that this kind of event is important. It's not just a discussion for those who happen to be in the Zoom room, but we hope we're going to create externalities of public good that can be exploited further than just this time. So with that, I think I will say goodbye, and with great thanks to the ECGI staff, the Milstein Center staff, with whom, I mean, it just went off so well. I mean, I sort of remember, excuse me for a minute, but back in March, when there was a global thing that the GC put together, we weren't quite sure that this thing with Zoom would work, right? That we could manage to have folks coming in and out to hold it together from all over the world. And now we've become quite experienced at it. I hope this is a skill that will die in its use over time to some extent, but nevertheless, it's a great way to bring folks from all over the world together who may not be able to get into a plane to be in the same time, in the same space. So thank you very much. And I guess it's time to call this to an end.
Thank you very much, Jeff.
Thank you, Jeff.
And I should also thank you to Vanessa Koenig, who also worked on
yes,
for ECGI. And the next thing, Jeff, of course, will be 3D meeting conference software. And I'm looking forward to seeing what you look like as an avatar. So thank you.
All righty. See you guys.